Okay, so we'll go ahead and get started. Thank you everybody for joining me today. We're going to talk a little bit about special needs trusts in Arizona. I want to take a second just to introduce you to myself and my team. I see a few familiar names, but also know there's some new individuals joining us. So my name's Emily Taylor. I'm an attorney licensed in the state of Arizona. Of course, you probably saw my legal disclaimer that none of this is technically legal advice, but we will learn a lot today. I grew up in the Midwest, but have been in Arizona for, I guess, 23 summers. Is that how we count our time in Arizona? And so happy it's cooling down here. But I attended both ASU and U of A, so I can root for either team. And I've been really, really lucky that for the last 15 years, I've been practicing in an awesome area of law. And so I've really focused my practice on estate and special needs planning. And I'm very thrilled to be a member of the Special Needs Alliance, as well as the National Academy of Elder Law Attorneys, State Bar of Arizona, and lots of other organizations. And I feel really lucky to be able to practice law in the state of Arizona. One of the good things, a few good things about the last couple of years is that with more access and availability of online and such, really excited to be able to see and meet with clients virtually and in person throughout the state. So with that, I've got an awesome team, and I'm sure if you've worked with us, you recognize many of these faces, but feel very fortunate to get to work with this great group of women every day, and look forward to kind of sharing some information about special needs trusts today. So our agenda is actually going to cover a couple things. Now, I will tell you that there are a lot of other webinars on some of these topics. And so today we're going to go at a pretty high level over estate planning to start, just to make sure everybody has a good foundation or a good reminder of some of the elements of an estate plan. And then we're going to talk more specifically about government benefits. Again, a pretty high overview, but just to make sure we can put them all together, then we're going to talk about special needs trusts and how special needs trusts work in both estate planning and other elements to protect government services and government benefits. So that's kind of our agenda today. Like I said from the start, please feel free to ask questions. I'd be happy to do my best to answer them, as long as they're not very specific, should be able to cover some things. And so with that, we'll go ahead and get started. One of the first things I like to review, even if you've recently done an estate plan or if it's been some time, estate planning components often fall into our vernacular as we're thinking about all the words related to special needs trusts. And so I want to generally go over estate planning just so as I use some of these terms, they fit in the context of what we're thinking about today. So I'll just briefly go over common estate planning elements. An estate plan is generally a series of legal documents and decisions that we put in place. Sometimes they're formal written documents like a will or a trust. Sometimes they're beneficiary designations. A lot of times how we own assets is part of our estate plan. But commonly you'll see here, we've got a couple big groups of documents. The first is healthcare directives. We'll briefly review those. Second is last will and testaments, or trusts and trusts. And then we've also got those financial powers of attorney and other elements that compose or comprise of a full estate plan. And so if we break it down a little bit, the healthcare directives, just real quickly, are commonly here in Arizona, include a healthcare power of attorney. This is going to be a document that allows you to nominate agents to make decisions for you when you can't make or communicate those decisions yourself. Hopefully we've got a backup or two. It's pretty typical in Arizona that in the healthcare power of attorney, we may also make some decisions about organ donation, your choices and electives as it relates to an autopsy, as well as any funeral, burial, cremation wishes that you might have. So that healthcare power of attorney is really quite dynamic. And our goal with that is that we've got a team or a lineup in place of people who can step in and advocate for you if you can't make or communicate your own decisions. And with that, having an effective healthcare power of attorney commonly allows us in the future to avoid a guardianship matter. We also in Arizona have mental health care powers of attorney. These are specifically for mental health treatments. They often include authority to admit somebody to an inpatient psychiatric unit. They're important to avoid an emergency guardianship. So a good element just to make sure you double check you have in your estate plan a part of that. There's also going to be a living will. A living will is much different than a last will and testament. A living will is instead going to be a reflection of our wishes or intentions about our healthcare treatments. If we're unable to communicate, but specifically as it relates to sometimes end of life decisions. And so commonly it's going to direct quality of life. You're going to be allowed to share some perspective on what your wishes would be in terms of ongoing life prolonging measures, including feedings, as well as artificial hydration, comfort care. Some living wills are also going to allow you to address what level of healthcare you would want and specific things that would be the case if you have advanced Alzheimer's or dementia. But broadly, we're just trying to give our agents some guidance about our own intentions, our own reflections on what we think we would want for ourselves if at that point we're no longer able to make our own decisions. So very important, but somewhat confusing because a living will is very different than a last will or a living trust. So despite the fact that attorneys often get a hard time for using a lot of complicated words, turns out we can also repeat those words and have very different meanings to them. We're also going to want to make sure we've got HIPAA language in place, making sure our agents have right access to everything we need, as well as you may potentially have a do not resuscitate, a pulse form, or other specific directives. So I know that's a quick overview, but very important elements of a healthcare power of attorney. We're also commonly going to have financial directives. These typically include a financial power of attorney, sometimes called a general or a durable or a property power of attorney. The title itself doesn't matter so much as the robustness of the authority you've granted under the financial power of attorney. So same thing, we're trying to make sure that if at a point we can't make or communicate our own decisions, and we've got that trusted lineup in place, that we give the proper authority to the right people or professionals so that we don't have to go through a conservatorship process with the court. We also, I tend to bring up here some things that are really important because we need to understand that they might supersede our written estate planning wishes, and that is co-ownership on accounts as well as signatories. We have powers of attorney with each financial institution in some cases, and we may have other pieces that go along with our written estate plan. So it's really important to understand how your personal financial assets are currently titled and who has authority and the ability to direct or ask questions. With the last will and testament, these tend to be the ones that we see a lot in movies and we're kind of familiar with the concept. It's a document that's going to allow us to make a couple of decisions. Usually we're thinking about the power to nominate or decide who's going to manage our estate. In Arizona, we call this role a personal representative, but commonly you hear the term executor. We also, in a last will and testament, are going to be able to nominate a guardian for our minor or incapacitated child or children. And this can be really important as we're talking later today in more detail about special needs trusts. If you have an adult child who is under guardianship, we want to make sure we have our successor guardians nominated and lined up there to make sure that's appropriate. And then ultimately, a last will and testament is going to direct the distribution of estate assets. Now, with that, one thing to mention is, again, any assets that have a co-owner or a beneficiary designation, that title or designation is going to supersede what might be in our last will and testament. And so when we mention estate assets, we're referring to the assets that do not have a beneficiary designation and do not have a co-owner with rights of survivorship. In the case of a last will and testament, that personal representative or executor we may have nominated holds no authority to act until they've been formally appointed by the court. And that appointment process and the ultimate supervision of the estate administration is what we commonly think of as probate. And so probate is that court process that gives the last will and testament the power it needs to allow somebody to act, to collect your assets, to pay final expenses, and to ultimately follow your wishes. So a last will and testament is very important. However, the downside is that because it requires a probate to be in place, sometimes that can result in a delay. It can result in additional costs, legal expenses, as well as other things that may come up. And it's also a public proceeding that requires notice be given to certain individuals that we may want to have a more private estate administration. And so with that, quickly, and honestly, I could spend probably an hour on each of these slides, but quickly then, a lot of times we are commonly looking at a revocable living trust to be an element of our estate plan. And so some of you may have trusts. The revocable nature means, of course, that you can continue to change your trust while you are alive and have capacity. Living means it's created while you're here. In that trust document, we're commonly going to nominate the different players. That may be a trustee. It's going to be a trustee, successor trustees. Sometimes we have trust protectors. Sometimes we have advisors. We're also going to spell out who are the beneficiaries. Now, the terms of the trust are going to direct the administration of the trust during several periods of time. One is while you're alive. The second is at incapacity, and of course, after death. It often commonly also includes ongoing administrative provisions for minor children, for adults who have special needs, for other circumstances. And so a trust tends to be a more robust document. And one of the benefits of a trust, if properly funded, I'll talk about that in a second, is that we get to stay out of court. So probate avoidance is possible if we have a trust document that has properly been structured by going back to our assets and looking at ownership, legal title, and beneficiary designations. Because again, those co-ownerships, those beneficiary designations are going to supersede the terms of our trust. We need to make sure that, for example, our home is retitled, that it goes from us as individuals to potentially us as trustees. We need to make sure our bank accounts are properly titled. We need to make sure our retirement accounts have the right beneficiaries. Funding of the trust is very, very important. And so you may have been through this process. You may have already signed a revocable living trust. It's always a good idea to take it off the shelf and wipe off any dust and double check that not only are the terms of your trust, your powers of attorney, and all your other legal documents still accurate, but that they also are titled appropriately in terms of your assets. So going through things you've acquired or accumulated in the recent years, making sure beneficiary designations are in place, all of that. So that was a very quick 10-minute review of kind of some estate planning basics. Of course, there's a lot more to know and there's a lot more components, but that gives us a good foundation to start thinking about or talking about special needs trusts. Now, one of the things we're thinking about when we're thinking about special needs trusts tends to be what's the benefit. And when I say benefit, I suppose I'm saying pun intended, because benefits, or this idea of a special needs trust, is largely to make sure a couple of things are done. One, just like our other documents we've been talking about, we need to make sure our right team is in place. So we're going to talk about that in the special needs trust, what kind of players we have who are appropriate to serve in those different capacities. We also primarily are trying to make sure that the beneficiary of our special needs trust, who may be receiving government benefits, has protection, meaning that the assets don't disrupt or disqualify that beneficiary from receiving ongoing support. So right now we're going to take another few minutes to talk just generally about some big groups of public government benefits so that we're all on the same page as it relates to the special needs trust and what it's going to protect. So quickly on here, you can see we're going to talk about Social Security, we're going to talk about Medicaid, and then a few other benefits. There are many different organizations, and there are many different financial and insurance programs that people qualify for. It'd probably be impossible to cover all of them, but today we're going to highlight the big ones that a lot of individuals in the state of Arizona are receiving. but it's really important that you have a full snapshot or picture of what a beneficiary might be receiving. So first of all, if we're going to talk quickly about Social Security, I just chuckle because Social Security is not a quick topic, but it can be. We commonly are familiar with Social Security in the sense that a lot of individuals will receive Social Security retirement benefits. The amount of Social Security we'll receive at retirement is dependent upon how much we've paid in and for how long. This is also true that when we get a paycheck, we can see some portion of that check has gone off to purchase or provide for Social Security. That also is commonly thought of as the investment we're making for Social Security disability insurance. And what Social Security disability insurance, often called SSDI, is that when a time comes in our future, if we've paid into Social Security and are eligible for a benefit, and at a later date are no longer able to be substantially gainfully employed, we've been determined disabled by Social Security, and we've paid into the system, then we're going to get an insurance payment each month in the form of SSDI that allows for us to continue to have income if we're unable to work. Now, that Social Security disability insurance program that we've paid into does not require that the individual who's receiving SSDI have certain financial criteria. So it's important to know what type of Social Security you're on, because alternatively, for many young adults and even some older adults, if they don't have the history of paying into Social Security, they are commonly applying for and eligible for Supplemental Security Income, SSI. So there's a big difference between SSDI and SSI. And sometimes individuals who are receiving Social Security don't know which program they're on, and that's fair because it's very confusing. So with SSI, it's really important to know because SSI is only eligible to individuals who meet certain financial criteria as well as disability criteria. And that financial criteria, and the reason it's highlighted on this slide, is because a recipient of SSI is not able to have more than $2,000 in countable resources month to month. And so we need to be really, really cautious about the carrying balance of their bank accounts, what money's coming in, what they're spending that money on. SSI is very sensitive to other income. So if they're working, that income needs to be reported and it gets offset against the SSI. SSI also is very sensitive to other people or trusts paying for food and shelter, what we would call in-kind support and maintenance. So SSI, which in 2023 right now in Arizona for most beneficiaries is $914 at the max. That $914 would get reduced by a third in the event that individual is not having to pay for food or shelter because somebody or a trust is paying for that for them instead. And so SSI is tricky. We got to be careful. It's very sensitive. It has a lot of strict criteria. And if at some point it's determined that you've been ineligible for SSI, perhaps there's been $2,010 in your savings account month to month, and this is later disclosed or learned from by Social Security, there is going to be a repayment. And so it gets really tough and tricky to make sure that we keep really close eye on this. And of course, with that $2,000 limit being as low as it is, it's also really important that we make sure that as we're planning and we're talking about special needs trust, we're careful with inheritances people might receive or gifts or other types of transactions. I also have on here disabled adult child benefits, DAC, sometimes or previously referred to as childhood disability benefits. This program is for individuals who are determined disabled before age 22, and at the time their parent, one of their parents, starts to take Social Security, their benefit commonly changes from SSI to this disabled adult child benefits. And that allows the beneficiary to receive Social Security in an amount that is calculated based off of the parent's earning record. And so what they're looking at is mom or dad's contributions to Social Security, and if that parent is eligible for an amount of either retirement, Social Security, disability insurance themselves, or they've passed away, then there's going to be a calculation. Commonly, that disabled adult child benefit is going to be more than the $914 for SSI, meaning the SSI goes away. And now this individual is receiving a Social Security benefit that isn't as sensitive. It still requires, of course, that they are disabled in the eyes of Social Security, unable to participate in substantial gainful employment. But it is not as sensitive as it relates to the resources and other aspects that we've kind of been talking about here. And then, of course, there are a number of other types of programs under Social Security that you should be aware of, such as survivors benefits, caregivers benefits, and so on. I mention all of this because a lot of times it can be a big puzzle. And it is possible for an individual to receive a portion of SSDI because they perhaps have been working for a long time at a part-time job, as well as get SSI to bring them up to that full amount. It could be possible that somebody's getting a portion of disabled adult child benefits as well as SSI. The other really important thing is that a lot of these Social Security programs are tied to other health insurance programs. And for example, with SSI, if you get $1 of SSI, then you're also going to get AHCCCS, which is Arizona Medicaid. And if you have been on or receiving Social Security disability insurance or disabled adult child benefits for more than 24 months, you also become eligible for Medicare, even if you're not yet 65. So it is a big puzzle. It's just important to know what you or your loved one who you're trying to protect their benefits has and how it's all connected and what's going to be in place in the event a special needs trust is going to be necessary. DDD, Division of Developmental Disabilities, is a program here in Arizona that is important for individuals who have a certain or specific diagnosis, and it allows them to receive coordination of services and care based on that diagnosis and the needs that are required. When somebody is receiving DDD, they also really are only getting services so long as they're also eligible for Arizona long-term care system benefits. So ALTCS, as it's commonly known, is also Medicaid, but it is the long-term care system benefit that many services are provided for in the DDD world, such as speech, respite, HAB, attendant care, all types of things, as well as for the elderly and physically disabled, nursing home level of care, group home settings, that type of thing. And so ALTCS is a really powerful benefit that does provide a lot of support for individuals. Eligibility for ALTCS is also quite tricky because in order to be eligible for ALTCS through Medicaid, you have to have medical eligibility, which is established through a pre-admission screening, looking a lot at activities of daily living, behaviors, and other items, but it's something you need to understand how medical eligibility is determined. You also have resource eligibility requirements, meaning we have to meet certain financial resource qualifications. Again, for single individuals, that's going to be that $2,000 in countable resources. There are some assets that are not considered countable, including the primary residence, one vehicle, your personal property, but again, a little tricky. And then income criteria and income eligibility. And this is, again, not the same as Social Security, but also something you really need to understand, especially as someone's income throughout their life may change based on the nature of the Social Security they're receiving, as well as their employment and other items. So ALTCS is very sensitive in the same way that SSI is. We need to be careful that ongoing eligibility is maintained through resource eligibility, income eligibility, and medical eligibility. Now, AHCCCS, Arizona Healthcare Cost Containment System, is the other Medicaid program that many of us are familiar with. A lot of times, individuals may use the terms AHCCCS, Medicaid, ALTCS interchangeably because it is a part of the same system, but it's important to know that each of these programs has different qualification criteria. Access, like I said, you may be eligible for access because you're on SSI. If you're also on ALTCS, you're automatically eligible for access. And some people are on access because they have low income. Some people have certain diseases or diagnoses, and so they're eligible for access. There's a lot of different ways you can be eligible for access, and so it's important to know. Access program in and of itself tends to be primarily focused on your income eligibility, but because it's tied to so many other benefits who have resource criteria, we want to make sure it all fits together. So if that's not the quickest, most convoluted explanation of some of the benefits we're talking about, I don't know what is, but I hope that was a little bit helpful just to make sure that as we start now to talk about special needs trust, we really understand what we're trying to do. Because in the end, our big goals are making sure that all of these important systems and programs are protected, or eligibility is maintained or at least made available. And it's going to allow for ongoing management of protecting all these benefits by having the right team in place, including roles such as that trustee role or other different roles that we're going to have. And so special needs trust components, a lot of times we're thinking about the term special needs trust. That too can apply to a number of different tools. So we really need to know all the different tools that are available. There are both first and third party special needs trusts. We'll go into detail about the difference there. ABLE accounts are another tool that sometimes allow us to have resources that are protected for purposes of maintaining eligibility. And then special needs trusts tend to be components of an estate plan, as well as certain assets within our savings and resources. We need to be aware of how that all fits together as well. So with that, I am pretty visual, and so if you've ever met with me in person, you've seen me draw some pictures, and I like to use this diagram here I've got on the screen to help us kind of figure out which path we need based on the situation we have in our hands. And so two big questions we're going to be asking when we hear or think about the term special needs trust are, where is the money coming from and what are we protecting? And so with that, you can see in this diagram here, we've got an individual in the middle of the page, and we can name them. I think on a future slide, I've named them Adam, so let's just call them Adam. In this case, Adam is receiving some benefits. And so we've got lined up here SSI, ALTCS, those are the two programs we just learned about. Now DDD, that's a little bit of a trick because DDD in and of itself doesn't have the financial criteria, but most commonly we think of it as providing or being the mechanism where we receive ALTCS services through. And so if Adam's receiving these programs and suddenly we're going to be having some money, it's coming from somewhere, in order to know what tool we need to solve that problem and to maintain Adam's eligibility for those benefits, we need to make sure we need to understand who the money legally belongs to and where it's coming from. We also need to make sure that, for example, if we're thinking in the future about Adam and we know, or we just learned that perhaps we're trying to plan for mom and dad's inheritance, that these benefits could change. And so while Adam might be on SSI right now, at the time mom or dad passes away, he may be eligible for disabled adult child benefits, and seeing if that might change our plan here. And so commonly, as you can see kind of off to the left of Adam on this diagram, we've got some resources. And if, for example, Adam is required, because he's on SSI and he's on ALTCS, to have less than $2,000, and we said, for example, there was a life insurance policy that his grandmother had, and his grandmother named Adam as the beneficiary. She didn't really realize that Adam was on these programs or how these programs worked. She thought she was being generous by naming him as the beneficiary so that when she passed away, he might receive $100,000. So if in our example, $100,000 is coming to Adam and grandma has now passed away, that money legally belongs to Adam. Now, I don't know, because Adam's a figment of my imagination, the nature of his disability, but a couple things may happen. First of all, Adam himself may not be able to solve this problem. He may have cognitive limitations. He may be under guardianship. and now he needs a conservatorship because suddenly he has $100,000. But what we know, or what his family or caregivers or planners know, is that Adam's not allowed to have that $100,000 and continue receiving his income through SSI as well as his insurances through ALTCS. So in that case, because the money belongs to Adam, we're going to need to establish what's called a first party trust, a self-settled special needs trust. These assets already belong to Adam, and in order to maintain that eligibility, we're going to have to figure out what to do with this $100,000. Of course, we could try to spend $100,000 in one calendar month, but we're going to have to spend it in the right way. We're going to have to disclose that all to the government agencies, and frankly, that doesn't make a lot of sense because $100,000, spending it on things that are not necessary, don't benefit Adam in the way Grandma intended. And so with a first-party special needs trust, we need to understand that in order to allow Adam to benefit from this money, as well as maintain his eligibility, there's going to be a lot of rules. These trusts are tricky. And one of the big pieces is that we have a lot of eligibility criteria. So a first-party special needs trust must be set up while Adam is under the age of 65. If Adam's over 65, we're going to need to undergo an entirely different analysis. But presuming Adam's under 65, we can establish and fund this first-party trust. Adam cannot be his own trustee. This trust must be irrevocable, and it must meet very certain criteria for both SSI and ALTCS to review the trust and to make sure it's eligible. One of the big things we need to know about a first-party special needs trust is that a first-party special needs trust, the primary remainder beneficiary after Adam has passed away, or if the trust is terminated during Adam's lifetime, is going to be the state of Arizona or any state in which Adam's received services. They'll have a right to make claim for reimbursement of those Medicaid expenses. And if Adam's been on ALTCS for several decades, there's going to be a bill that's going to be way over $100,000. And so any remaining money is going to go back to the state. And because the state is going to get what remains, these trusts tend to be very heavily monitored, and expenses have to be approved by the ALTCS agencies. Social Security can require a lot of auditing and background, and we must disclose a lot of different things and get pre-approval for expenditures. So in this case, a first-party special needs trust is commonly a tool we don't get a choice to have. We have a situation where Adam is receiving money. Now, it may be this $100,000 from Grandma's life insurance. It may be a settlement from a fender bender. It may be his own savings. And we need to use the first-party trust to solve for making sure Adam retains his benefits. On the other hand, if we think about ourselves and what we're trying to prepare for, if that is that we want to make sure Adam is provided for at the time that his parents pass away, or even grandparents if they wanted to set it up, and we want to make sure that somebody else's money doesn't go directly to Adam so we can avoid that first party trust, we want to consider setting up a third party. A third party trust, on this diagram I refer to them as supplemental needs trusts. We can call them special needs trusts. We can call them whatever we like as long as they meet the criteria. But if other people want to provide resources financially in a way that are going to benefit Adam but not go directly to him, then we need to look at setting up this third-party supplemental needs trust or special needs trust. Now, these types of trusts are established through an estate plan commonly, and they can be standalone, meaning Adam's supplemental needs trust may exist right now. You may be able to go open accounts, or it could be what's called a subtrust. For example, you might have a revocable living trust, and it might say that when you pass away, each of your children receives a third of the estate, and the portion for Adam is going to go into a third-party supplemental needs trust that gets created at that time. And so we really want to understand what we have there. And again, we want to make sure that our assets are structured to flow correctly into that third-party trust so that we can bypass the need for having that first-party trust, as well as that conservatorship and the risk that Adam may have direct access to these funds, and it may be vulnerable to having undue influence or somebody else to come in and take advantage of the situation. So if we're in a situation where we have an opportunity to plan and we're planning for money that legally belongs to somebody other than Adam, then third-party trusts are a great solution or tool for our ability to do that. So let's kind of review all of that a little slower. So if we're focusing on a first-party trust, this is the example when money has already legally become Adam's. It's common for settlements. It's common for inheritance that is not properly structured. And as I mentioned, it's common for individuals who have savings that need to be protected. And so that first party trust has to be irrevocable. Now, irrevocable means once we've set it up, we can't change the terms of it. Or if we can, they're through very specific provisions that may allow a trust protector or a court to make certain changes. It must be established and funded before age 65. And that's Adam's age or the beneficiary's age. They need to be under 65. It's funded by assets that belong to the beneficiary. And so that's legally belong to them. So many times people may say, well, my assets are in a conservatorship, for example, that doesn't have or allow for direct access for Adam, but it legally belongs to him. Those assets will make Adam ineligible for services. As I mentioned, first party trusts do have a lot more oversight by government agencies and sometimes by the court. Commonly for an individual who can't approve their own settlement, we need a conservatorship and we need the court to approve the settlement. And so a lot of times court will have ongoing supervision of those. Sometimes they have to be administered by a trustee who's a professional. A lot of different circumstances go into that. And again, one of the big things that stands out with a first party special needs trust is that assets that remain at the termination of the trust are commonly paid back first to the state for services. Now, sometimes there are situations where the balance of the trust may exceed any claim made by the state, but that's pretty rare because somebody who's been on long-term care through ALTCS for a long period of time has a pretty significant bill with the state. There are also a lot of rules and restrictions on what these assets can be used for. Now, our goal is to allow for a way to find that most of these things can be paid for if we can, but one of the other really big rules is that a first party trust has to be a sole benefit trust. And a sole benefit means it can only benefit Adam. And so if Adam's living at home with some siblings or his parents, and we're looking to get approval from ALTCS for a distribution from a first party special needs trust, we're going to need to understand how many people live in the home with him. And so if we need a new washer and dryer, if there's 4 people living in the home and Adam is one of 4, then he can pay a fourth of that expense because the distributions from a first party special needs trust need to be for his sole benefit. Of course, we're always looking to make sure that that's the case. Now, if Adam, based on the nature of what's going on with him, needs a high-tech, very specific type of washer and dryer for allergens or otherwise, then perhaps we can get a doctor's note indicating that this type of specific thing is needed just for him, and then we can take that to ALTCS to get permission to allow to purchase the whole thing. But there's a lot of unique considerations. Now, commonly, first party special needs trusts are going to be used for services that are not covered by ALTCS or other government benefits that you're on. And as I mentioned with the first party trust, if you're receiving ALTCS benefits, every distribution needs to be pre-approved. And so the process of going through what we call an anticipated disbursement worksheet is as if we're setting up a budget, we get approval of that budget from ALTCS. But then if we have an emergency or something come up where we need to use some additional funds that were not considered or not a part of that anticipated disbursement worksheet, we're going to need to go back to ALTCS to get permission for that purchase. So very complicated and tricky. Of course, it's important to make sure we've maintained eligibility for benefits, but we're always going to analyze that. So if there were a situation where we had an amount of money and we had a beneficiary, one of the important things to do is to work with an attorney who really understands all the alternatives so that you can fully ensure that the program, the benefits you're getting, all of that you set up the right way or mechanism or tool. Now, with that being said, if we focus then on the third party trust, As a reminder, these are trusts that are created by somebody else on behalf of a beneficiary with special needs who may be receiving government services. And it's funded directly with assets that never belonged to the beneficiary, meaning they go directly from mom and dad or grandma and grandpa. In the example I gave, instead of grandma naming Adam directly, if she had instead set up a third-party trust and named Adam's Supplemental Needs Trust as the beneficiary, bypassing Adam directly, we would have avoided a conservatorship in that first-party trust, and that third-party trust could be funded. These trusts also protect benefits, and at the end of the day, if Adam doesn't use all the assets in there, the person who created the trust can decide where the remaining benefits are going to go, whether that's back to other family members or to charities or other organizations. And so with the trust maker being able to do that, there's more flexibility. And also, given the nature that the state's not going to recover what remains in the trust, oversight of these trusts does tend to be a little bit different. Now, disclosure is still required. You're still required to notify any agencies when there's been a change in financial circumstances. And in this case, even the establishment and funding of a third-party trust may require a disclosure status, but a lot of times the agencies are not going to do a whole lot with these trusts. They're going to make sure they're properly administered, and you do need to be careful. But that's important. So as a family member, if you're setting up a third-party trust, we do want to make sure that there is other oversight. So sometimes that means we're setting up a team of trust protectors who may have an opportunity to review accountings. Adam may not himself be in a position to understand if the trustee is taken a little off the top or doesn't have good investments in place. And so we want to make sure that there's some check and balances and oversight. It's also a good idea with a first party trust, but we do know that the state's going to be looking more closely at that first party trust. And so the third party trust, because we're allowed to get a little bit more creative, as long as Adam himself, the beneficiary, is not the trustee and can never be the trustee and will not be the trustee, and the trustee, who is not Adam, has discretion to use the money for items that will supplement special needs benefits, then this trust is going to be considered an excluded resource and not going to cause a problem with benefits. Now, I will also kind of cover quickly ABLE accounts. Many of you are probably familiar with ABLE accounts. ABLE accounts are a tool that do also allow for resources to be held in a way that does not disrupt benefits. ABLE accounts, however, can be used to hold both first and third party resources and income, but they are limited to a total annual contribution, not per person, not per anything, but total. So all of the grandparents, all of the parents can't contribute more than $17,000 a year to an ABLE account. There is a slight exception that we can go above that if, in this case, Adam is working, he can save some of his own income. You can use or participate with any state's plan. So there are resources online. There's a couple of really good websites that allow you to compare state by state the different ABLE accounts that are set up. And it does not have to be set up in the state of residency, but maybe something to consider. And funds in those ABLE accounts are permitted to be used for qualified disability expenses. So a little bit different than the first party or the third party, but important to understand, and really a good tool to allow for some more flexibility of spending if appropriate. And the resources in here don't disrupt government benefits. So important to know. Now, with ABLE accounts, you do, to be eligible, you have to have been disabled with an onset of disability younger than 26. Thankfully, that is soon going to change to 46, but it's not in place yet. And you need to either be receiving SSI or SSDI benefits, or if you're not eligible for those Social Security benefits, you can continue to meet that disability criteria by having a letter from your physician. So ABLE accounts are a tool, but they're limited. And so in the case of an inheritance, right, grandma's $100,000 life insurance policy, we're not going to be able to use an ABLE account because we can't put $100,000 in. We're limited to that $17,000 contribution limit. So commonly ABLE accounts don't work well for inheritances that parents or grandparents want to leave. And if the amount of resource or asset that the beneficiary has is well over the $17,000, it's not going to be good or appropriate for that settlement or that unprepared for estate plan. So just important to know the limitations, but also other good reasons to investigate ABLE accounts. The one thing I will also mention, so if we're reviewing, right, we're kind of narrowing it down. If we're talking or focusing again on that first party money, if Adam is trying to protect his SSI or ALTCS, then that first party special needs trust is going to be used, unless of course the assets that we're trying to protect are under that $17,000. Both the first party trust and the ABLE account are currently claims can be made by the state for reimbursement or payback at the time Adam passes away. If there's funds in a first party special needs trust, or if there's funds in an ABLE account, our Medicaid agency through its collection agency can make a claim against both of those tools. And so to the extent we can, we want to try to prevent or prepare so that we don't need to use these unnecessarily. Now, there's no way we're never ever going to need them. We can't, prepare for if Adam might be an offender bender and receive a settlement. We can't prepare for somebody unintentionally being generous. Although one of the things I will say is communication and disclosure is really important, because I know a lot of people in your families want to provide for and help, all of our beneficiaries, but making sure they're educated about the nature of the benefits and how that's received is really important. Quickly then, on the other hand, this third party trust, which is either a standalone or a subtrust, is something that we want to establish in our estate plan. So if we kind of go back to the beginning of our conversation and we're looking at our wills and our trusts and we're planning for our children or grandchildren or nieces and nephews or just a close friend, we want to make sure that our estate plan specifies that any assets that we might leave to somebody who might be receiving mean tested resource income, all those things we went over, benefits, that it goes directly into that third party trust, and that we've got the right team and the right lineup to plan for that. And so big picture, just need to know where the money's coming from, what we're trying to protect, and what tools are appropriate. So with that, I'm going to ask some questions. I see we've got a couple popped up here, so give me just a second. So the first question is, are there attorneys who can assist setting up a special needs trust that can also be a trustee and or a fiduciary? So that's a great question. So for example, a trust, like a supplemental needs trust, is going to need a trustee. That means somebody who's going to collect the assets, manage distributions, pay taxes, that type of thing. There are attorneys who can set up the trustee and be the fiduciary. They are very few and far between, because in a lot of ways the skill set between an attorney who prepares the plan is different than who's going to step in to be administering the plan. And there's also a lot of differences between how that trustee is going to get compensated. And so it's common, if I'm the attorney working with a family or an individual, to make sure that we've got a trust in place. We're going to talk a lot for a long time about who's appropriate to be that trustee, because in many cases it may not be appropriate for siblings or other more distant relatives or friends to step into this very important and frankly kind of difficult role. And so we're going to talk about all the different types of professionals. So there are trust companies that will be a trustee. There are licensed fiduciaries who can be the trustee of a special needs trust. We're going to look at all the factors and figure out what's best. So the short answer is yes, there are attorneys who are both trustees and who will do the trust. It's very rare, and I think it'd be hard to maybe find, but it's possible. And there are a lot of other types of professionals who are licensed, supervised, have a lot of auditing and that type of thing, who can be a trustee of a trust as well. So definitely want to consider that when we're thinking about who might step in as trustee. Okay, another question is, my husband retired from the sheriff's office. He currently receives monthly retirement. However, when he passes, any entitlements left are to be distributed to the spouse and disabled adult child or disabled adult daughter. Will daughter lose her income, and does she need to set up a first party trust? We are gathering info to set up her third party trust. So the benefits, I'm anticipating, and forgive me, I'm having a moment, but I think sheriff's office benefits would be Arizona State Retirement System, but I'm not positive. But either way, we have to look at the benefits daughter's going to be receiving. And so what we know is that if her father has passed away and he's been working, daughter, if she was determined eligible for Social Security before 22, will no longer be receiving SSI. She instead would be on disabled adult child benefits. So we don't need to worry about SSI for the income piece here. And so then if we're just trying to protect daughter's ALTCS benefits, we actually have a much higher income threshold for ALTCS. And so income threshold for ALTCS is going to be about $2,700 right now, and it gets adjusted every year. The other thing is that with ALTCS, we can use what's called an income-only trust, a different type of special needs trust that we didn't really cover today, but it's just for this income problem. And so the short lawyer answer is it depends, but what we're going to want to do is we're going to want to look at or estimate what we think daughter's disabled adult child benefits or Social Security benefits are going to be, as well as what we think the pension benefit's going to be, determine if that's potentially going to put her over income eligibility for ALTCS or any other benefits, but she may not be on SSI, and then just make sure we figure that out. So whether or not a first party trust is needed is really kind of tricky because it's usually not needed just for income if we're planning just for ALTCS. Usually we can use an income only trust or another tool to fix that. And sometimes you can direct benefits into a third party trust, but it depends a lot on the agency and that type of thing. So complicated answer, but it's something that you could look at more specifically for your specific situation and figure that out. What other questions do we have? I don't see any else. So one of the other big questions is, who should I go see to do this? Of course, I'd love for you to come see me, but that's not absolutely necessary. I'm not doing this just for that reason. But you do want to really make sure when you're working on a special needs trust that you're working with an attorney who understands special needs trust, but also practices in this area regularly. And I'll just say that because a lot of attorneys do practice in the estate planning world. And estate planning is something that a lot of people are able to put together. But this specific piece, if we've got a beneficiary of our estate plan who's going to be receiving government benefits, we really, really, really want to make sure we're setting up the right type of trust. Because unfortunately, I've reviewed a lot of documents over the years, and it's rare, but very scary when I see somebody come in who thought they set up a third-party trust, but that third-party trust has first-party state payback language. So you just really want to work with somebody who knows specifically about the benefits. And so there's a couple go-to resources online to find an attorney. The first one is the Special Needs Alliance. They're a great website with a lot of information, more you can learn there, but they also have a find an attorney in your state. So if you're not in Arizona, or you don't want to work with me, there's other attorneys on there, and that's a good place to look. National Academy of Elder Law Attorneys is also a great place to look. Seems a little strange. Elder law does not necessarily, in my mind, connect with special needs benefits, but they are closely related, and attorneys in the NALA community do a lot of special needs planning. And then there is also the Academy of Special Needs Planners. So a couple organizations that are very specific for this particular situation, and going to look that up. Many attorneys, when you meet with them, will have a free consultation for the estate planning. Some attorneys, including myself, if we have a first party trust, may charge for that consultation. It's usually well worth the investment just because we're protecting our planning for so much. But that free consultation for the estate planning, an attorney should review with you what's appropriate, learn about your goals, learn about your family, understand the benefits some of your beneficiaries may be receiving. And commonly, I'm going to, at the end of this initial consultation, quote a flat fee based on what you need. And so just important to understand the scope of the project, what the benefit is for you, what it's going to look like in the long run, and then it's helpful to know what that cost is up front so you can make sure that it's a good fit for you. So good idea to ask a lot of questions, get second opinions, all of that. And if you do have a estate plan in place, a first or a third party trust as well, it's never a bad idea to review it. It's called the practice of law because we're always looking at things differently. And with that, you want to make sure you've reviewed the trust, that you understand how ALTCS and Social Security are administering things now, because it's not the same as it was yesterday, and it's definitely not the same as it was 5 years ago. So things are always changing. So if it's been a minute since you've prepared your estate plan, a good idea for yourself to review the people you've named, the different terms and specifications you have in place, and then make sure you work to update that. So not seeing any other questions pop up. So with that, I'll start to wrap up. Of course, seems a little silly, but we do our best here at the practice to share information. So if you feel comfortable doing so, you can consider following us on Facebook, Instagram, or YouTube. We've got a lot of resources we'll put up. And as I mentioned, I'll put this video up there as well. We have a couple fun things coming up this fall. We're going to be participating in the Golf for Inclusion with Autism Life and Living. We're also going to be at Yes Day for SARC. And we're going to be involved with Empowered Theater, their shows, the Courageous Cabaret this fall. So lots of fun things going on, and we try to stay really active in the community as well as provide some updates for our clients. So go ahead and follow us there. And with that, I'll just say thank you. You survived an hour of special needs trusts. I know we talked a little bit about estate planning and then government benefits, but hopefully we were able to put it together for you for the special needs trust component. Please feel free to reach out to me. You can call us at the firm. You can schedule an appointment through our website. And we're also, you may email me if you'd like. And with that, I'll just say thank you for your time today. I appreciate you, and happy to answer questions if anything else comes up. And I hope you have a great rest of your day.